Well, hello, YouTube. I'm Vince White. I'm an employment attorney, and we are responding to creator content on YouTube today. This is kind of a new thing for the channel. We've done this once or twice before. There is an attorney out of California named Branigan Robertson who has a very good employment law channel on YouTube. And generally, let me be clear, I am a fan. I'm a fan of Branigan Robertson. I think he creates great content. I think he helps people. I think that's important, and I wish more people were doing it. So, while I may at some points disagree with Branigan Robertson, I want to be clear. Great content, seems like a great guy, handsome fella, fan, okay? Now, he is doing what looks like an arc, this whole story arc on the beauties of arbitration for employment plaintiffs, right? And I assume he's looking at this primarily from the aspect of like workplace discrimination and workplace sexual harassment cases. And I think that's incredible. I think that's got tremendous value. I love that he's doing it. And one of the reasons I love that he's doing it is because there's not enough attorneys, especially plaintiff side attorneys, creating this content. And I've kind of touched on this before. There's some non-attorneys on YouTube who make videos on some of these topics, and some of them just make up 60-70% of their content, just say things that are entirely inaccurate, just nonsense. And their credentials for these channels that they're creating are that they had one case, which is fascinating, right? Like there was one who was talking about how she sees retainers where people pay hundreds of thousands of dollars up front and then they pay 50% contingency, and the lawyers end up making more than the person ever gets, so the person ends up paying hundreds of thousands of dollars. And it's like, I've never seen a retainer like that. I've never heard of a retainer like that. I don't know what client or what plaintiff would be able to enter into a retainer like that. Like, to pay hourly and then a percentage on top of that through the entirety of an employment case makes no sense, right? It's just this person, I guess it's theoretically possible that this person saw such a retainer. I don't believe the representation that that's a common retainer they see. I've never in all my life, criticizing employment attorneys nationwide, as I do, basically a hobby of mine to criticize employment attorneys in this country, in all 50 states, right? I've never come across that retainer agreement. So I think maybe, sometimes folks just get excited and they like having a voice and they say zany things to get more attention, right? So I digress. My point is here, Branigan Robertson is putting out great content and has value, and I believe fully that Branigan Robertson has a depth of knowledge in this field. I believe he's done many cases, right? Repetitions breed experience. They build us into better attorneys, in my opinion. The other reason I like Branigan Robertson is, of course, that his name sounds like Zap Branigan of Futurama fame, and that character always made me laugh. So, let me be clear. Branigan Robertson, if you're watching this, I'm a fan. And I'm sorry I'm going to disagree with you about a couple of these things, okay? I'm going to link this video down below, and he does great work. So he has the chapters on his video, and we are specifically going to be responding in this video to only one chapter of his video, which is the differences between court and arbitration. And that begins at the 3-minute and 53-second mark in his video if for some reason you're not seeing the chapters. Now, you go ahead and listen to that video if you want. Come on back here, and we'll talk about it. I'll give you a moment to do that. All right, we're back. I hope you paused. Okay, so first things first. He says that arbitrators are always paid by the company. I work as an arbitrator. That is false. That is an issue with certain employers, right? Like, if you're working for New York City and you're going to arbitration, I'll be frank with you, I have long believed and contended that New York City, because they pay for their arbitrators completely, keeps a list of arbitrators, and when an arbitrator finds against New York State too often, they just take the arbitrator off the list very quietly and never say anything about it, right? So yes, that can be an issue, but I'll be frank with you. I don't think I've ever arbitrated a case where I was solely paid by the employer. I believe, if my memory serves me, that every single case I've ever arbitrated as a sitting employment arbitrator, I was paid equally by both sides. Does not mean that Branigan Robertson is wrong. That is an issue, and I agree with him that that is an issue when the employer is purely paying for the arbitration. It can be, at least. It becomes more of an issue where there's a higher volume of arbitration, right? Like in New York City, they're clocking tens of thousands of arbitrations, so it becomes a real issue because they just get rid of people when they don't like the findings. If it's an employer that almost never goes to arbitration, I don't really even see that as an issue necessarily, but it could be. So I'll stipulate that it could be an issue, and it's non-ideal if the employer is paying for everything. The second thing I'll raise, and I don't think he meant this, or I think I might be misunderstanding what he said, but he seemed to say that arbitrators are allowed to have conflicts of interest. No. If that is what he was saying, and I'm sure that's not what he was saying, that is patently false. That is simply not true. Perhaps the laws of California are different. Entirely possible, right? I'm based out of New York, and I've arbitrated across the country, but never in California. The conflict check that I go through on a case is equal to, in every way, the conflict check that a judge would go through if sitting on a case, or even an attorney goes through if representing someone on a case, right? The conflict check is extensive and incredibly important, and it is a main feature of arbitration. It's one of the defining characteristics, and I do not agree at all in any way that arbitrators are just willy-nilly taking cases and failing to disclose conflicts and everything else. That is not something I have ever seen in my life as a plaintiff's side attorney or as an arbitrator. Just not factually accurate. Not saying what he's saying is wrong or that he's lying. I'm just saying it appears that our experiences on that particular issue have been night and day different. Okay? Next, and this was key. This is not something I disagree with him about, but this was something that I thought he may not have put enough emphasis on. Attorneys select their arbitrator together most of the time, right? So I'm a plaintiff side employment attorney. I hire a fair number of arbitrators. You select arbitrators that will be good for your case. Why? Because you need to win your case to make money. So you're not running out and hiring arbitrators that you know are going to find against you, right? You're only agreeing to arbitrators that you believe will be fair and will give your client a fair shake and will do right by your client and that you can win in front of, right? So I want to stress, I do really want to stress that that's important. It's not the defense attorney being like, hey, we're going to hire this arbitrator who hates you and hates employees. That's not how that works. That is who the defense attorney will try to hire, and then it's up to your plaintiff side attorney to say, yeah, we're not going to do that. It's not going to be how this goes. Let's get the list out. We'll pick somebody we can both agree on. And that process is highly contentious because both sides are trying to get an advantage. But in reality, that highly contentious process creates a very fair process. You end up with an arbitrator that both sides will frankly admit is fair, right? All right, next. The arbitrator can severely restrict your lawyer's ability to gather evidence. That is factually accurate. That is true. So can judges. It's basically the same process, right? Like, discovery will be quicker on the arbitration track, but I do not believe that I've ever handled an arbitration where I felt that I had less access to discovery than a judge or a federal magistrate would have given me access to. And state court judges, I mean, I feel the average arbitrator will give you more access, in my experience, to discovery than a state court judge is likely to do. Part of that is just, federal judges, federal magistrates, and arbitrators tend to see more employment cases. Arbitrators see more employment cases because they come from the field of employment law, right? Or they're a retired judge, right? So generally, they're going to have a depth of knowledge of this field and know what kind of discovery needs to happen to give everyone a fair shake. A state court judge may not have seen very many employment cases in her or his career. I've been in front of state court judges who called myself and defense counsel into chambers and said, listen, I've never seen one of these before. Can you give me a quick primer on the field of employment law? And I got to tell you, I looked at defense counsel and we're like, you want a primer on the field? Like, judge, what? We can suggest a couple of books, but I don't know if we're going to be able to teach you the field in the 20 minutes you've set aside for this meeting in chambers. And that's just because that particular judge did not have a wealth of experience with the field of employment law, right? And you do the best you can, right? Not all judges are created equal. But an employment arbitrator will have a depth of knowledge. They will have spent their career, generally speaking, in the field of employment law, right? People are not hiring employment arbitrators who have never handled an employment case. That's just not true. So I don't think it's true that the average judge is necessarily going to give you more discovery than the average employment arbitrator. Generally, employment arbitrators are quite liberal with discovery, in my experience. And again, Branigan Robertson may just have different experiences. Things may be very different in terms of the field of arbitration in California. I don't know. I'm just saying I disagree, but I'm a fan. Fan of the concept. Okay. So now he makes a big deal in the video about the differences between a jury and an arbitrator. I think he skips a step there. So there's three options, not two, right? There's trial before a jury. There's a bench trial, which is trial before a judge. There's, technically in our field, a whole bunch of administrative law judges that are running bench trials all the time in various agencies across the country. And then there's a hearing in front of an arbitrator. And I think, to some extent, he leaves out the bench trials in all the agencies and you can have a bench trial in federal court. That can certainly happen, right? Now, do I think that you necessarily should? No. I'll get into when I think you should and when you shouldn't. But I don't think an arbitrator is really that different from a bench trial or a trial before an administrative law judge or just, a bench trial in front of a federal magistrate or a federal judge, right? These are common things. Cases go forward in that format in certain situations, and I don't think an arbitrator is different. Now, I will agree with Branigan Robertson. Juries are wildly different animals from arbitrators. And there are advantages. There are times when you absolutely, without question, want a jury on a case. There's no doubt. And he is correct when he kind of highlights that. When you want a jury is when you're not afraid of being in the public eye. So your client doesn't have to worry about creating documents on public dockets that are going to show up in Google and background checks. Your client is a talented communicator and capable of explaining her or his narrative in a clear-cut way and in a way that helps the jury to connect with that human being and empathize with that human being. 3, the situation is easily understood. I am not insulting the intelligence of juries. However, there's many studies that reflect juries tend to hear about 2 minutes of about every 10 minutes of testimony. They kind of tend to tune out. You know what? I might have exaggerated that. It might have been 2 minutes out of 5 minutes. Either way, it's well known and commonly agreed that juries tend to tune out during trials. They don't hear much of the testimony. And so, if you have a really complex narrative, or if your client's not a great communicator, or just if your client's got great earning potential and wants to protect her or his career, In any of those three situations, you don't really want to be on a public docket. An arbitration might be a really strong option for you because, for whatever reason, any of those reasons in there, the jury might not be the best option. It might be that the jury might not listen enough and you need to convey really complex thoughts. It might be that juries are not going to find your client sympathetic, right? I've represented people worth hundreds of millions of dollars who insist on wearing $70,000 outfits every day. Do I want that person sitting before a jury who might not find that their attitudes or outfits are very compelling or sympathetic? No, I don't. I don't want that person in front of a jury. That would be a mistake, right? I've had clients who are, without a doubt, people who are wronged and have a case. We're also just jerks and kind of hateful, right? It doesn't change anything. The client's still been wronged. You still want to help the client. What's right is right. Just because somebody's a jerk doesn't mean they should be the victim of sexual harassment in the workplace or workplace discrimination. You still want to right the wrong, but you probably don't want to do it in front of a jury. Because the juries would say things like, yeah, I hate your client. That's why I found again. I believed your client, but I hated him or her. And yeah, I didn't find for it. Well, that's not good. That's not a good option. And then just let's be frank. There's a lot of folks in the world whose careers are worth exponentially more than their employment case, and they might really want to bring their employment case. They might want to fight and get what's theirs and right the wrong. And arbitration might be a really good place to do that because it's not going to be public in the way that a federal docket would be, right, or a state court docket potentially, right? So, I think you can delve into this idea of jury versus arbitrator versus bench trial versus administrative law judge a little more than Branigan Robertson did. I think there's a lot of conversation to be had in that pocket. And I know what he's doing. He's presenting an overview. I'm saying I disagree, but I'm not saying he was wrong. He's presenting an overview, and I'm getting into the nitty-gritty. And it's kind of what we do in this channel. We hyper-focus, and this is a 20-minute video on the differences between bench trials, jury, and arbitration. Like, the average viewer is not going to watch this video, right? The person who's going to hyper-focus on this field and research at length is the person who's going to watch this video. And that's really why Branigan Robertson has, I think, like 30x, 35x the number of subscribers that I do, right? Because he's providing really useful, great content that's an overview. And that's wonderful and useful. I'm just saying I kind of do something a little different. I get a little more into the hyper-focused details here, and I'm saying I don't fully agree with some of the things he said. I'm providing detail on that. Now, the last thing I'll say, where I disagree with Branigan Robertson. He says there is no right to appeal a bad decision in arbitration. That, at least in New York, is just patently false. That is not true. You can appeal an arbitrary and capricious arbitration award. There is a specific process for that. There's specific motions to be like that process exists and is routinely taken advantage of. That statement, and I'll be clear here. I don't know the situation as much in California, but in New York, under New York law, that is just patently false. There's no truth to that statement whatsoever. Anyways, I'm going to keep going on this because I think he's creating wonderful content, and I just want to kind of supplying an underpinning a little bit. Yeah. Listen, I hope this is useful. If it's not, tell me. I might stop making it. If it is useful, like and subscribe. It helps me to help more people just like you.